Welcome back to the Constitutional Clarion. This video is about the dismissal of the Lang Government in New South Wales in 1932. I hope you've already seen the other videos on the events leading up to the dismissal, including the running conflicts with state governors, being Sir Dudley de Chair and his successor, Sir Philip Game, the pressure from the New Guard and its desire to overthrow the Lang Government, and the financial conflict between the New South Wales Government and the Commonwealth Government. In this video, I'll discuss the circumstances leading up to the dismissal and the actual dismissal itself. I've also decided to add a fifth video which will deal with the arguments that people make about the dismissal and whether or not it was constitutionally justified. The dismissal of a government does not normally come like a bolt out of the blue. There's always a long lead up where dismissal is frequently raised by the media and pressure is applied by people, including senior lawyers, to the Governor or the Governor-General, as the case may be. And this was certainly the case in 1931 and 1932 in New South Wales. The Governor, Sir Philip Game, who had previously had a distinguished career in both the British Army and, once it was established, the Royal Air Force, resisted external pressure to sack the Lang Government. He took the view that he could not dismiss a government upon the grounds of incompetence or mismanagement, and he rejected all petitions to this effect. Illegality, however, was another matter. The Lang Government sent a circular to public servants on the 12th of April 1932 instructing them to hold monies received and not deposit them into a bank. The money then had to be transferred to the New South Wales Treasury. This was the point at which allegations of illegality started to arise. Letters were published in the Sydney Morning Herald on the 14th and 15th of April from leading lawyers asserting that public servants were being directed to breach the Audit Act, a state act, by not placing trust funds in the required bank accounts. They asked, "Is His Excellency going to uphold the law or not?" On the 11th of April, 7 King's Counsel wrote to Sir Philip Game, advising him that if ministers were in breach of the law of the land, or indeed took action to frustrate the law in a manner that interfered with the carrying on of the government, the Governor was entitled to seek new advisers, which of course is code for sacking the government and appointing someone else. Professor Berrydale Keith also let his views be known in London on the issue of illegality and the Governor's discretion on the 15th of April 1932. He said this, quote, "The Governor normally is entitled to accept his Premier's statement of the legal position if it is fortified by a formal legal opinion, but he cannot disregard the law of the land when finally declared by the High Court, and it's his right, and indeed his duty, to refuse to be a party to any illegal action of the Premier and to decline to assent to any order in council which, in substance, is illegal. Moreover, he will be under the obligation of considering whether it is possible for him to leave Mr. Lang the authority of the Premier's office in order to defy the law of the Constitution," unquote. This opinion raised a number of issues. Should a Governor act upon advice by the Crown law officers, even if it is contrary to a decision by the High Court? What if the Premier refused to provide advice by the Crown law officers or even to deny the illegality? Should the Governor refuse to be party to an act which on its face is in breach of the law, as declared by the High Court, without seeking a further court determination about each such act? Who should bring such an action to determine the legality of such an act? What should the Governor do if the illegality does not involve a personal act of the Governor? These are all issues that loomed before the New South Wales Governor, Sir Philip Game. The Governor, in a secret telegram to the British Secretary of State for the Dominions on the 23rd of April 1932, explained as follows, quote, "Strong press and public pressure has been brought on me for last fortnight to dismiss ministers, though best responsible opinion expressed privately, but not publicly, disagrees. Today's papers, however, incline to latter view and take line that I can only watch events. Feel it is better that Commonwealth and states should decide quarrel without my intervention, but may have my hand forced by issue of legality of ministers' actions. If Commonwealth can and does get caught to restrain illegal action by states, shall of course hold my hand. But Chief Justice appeared to doubt possibility of this and fears public taking violent action if present position allowed to continue for long. This seems to me less likely in view of press attitude this morning. Feel quite clear that I cannot dismiss because ministers' actions offend my own or other people's sense of public integrity, however much warrant there may be for this opinion. Am not so clear as to whether I can do so on grounds of illegality of administrative acts not requiring my signature, or whether by doing so I should be usurping functions of the courts." Unquote. The Governor was concerned that the instruction of 12 April, which had been issued to his official secretary along with other public servants, might breach the Audit Act 1902. He wrote to Lang about this concern and asked to discuss it with him once the High Court handed down its decisions. This occurred on the 22nd of April. Sir Philip saw Lang that day and stated that he did not want to be in the position of condoning illegality by remaining inactive. The Premier then promised to obtain an opinion from the Crown Law Officers. Sir Philip reported to the Dominion's office that he then saw the Chief Justice and arranged to consult him if the opinion of the Crown Law Officers left any doubt in his mind. His telegram then noted, crucially, "Presume, and Chief Justice concurs, that I have no other responsible advisers and in the end must decide question of illegality for myself." Unquote. The Attorney-General came to discuss the matters with him, but Sir Philip insisted on a written opinion, which was later forwarded to him. Sir Philip told the King, quote, "On receiving it, I came to the conclusion that there was no clear basis on which I could act, and the Chief Justice whom I consulted agreed." Unquote. The Auditor-General had nonetheless reported on the 28th of April that provisions of the Audit Act were being breached. A draft response to the Governor's concerns was prepared in the British Dominion's office, but was never sent because it was overtaken by events. The Dominion's office took the view that if the Governor was advised to act in a way that he doubted was lawful, and the Crown Law Officers provided him with advice that it was lawful, then if he relied upon that advice, all responsibility for his act would shift to his ministers. If he received the legal advice that it was lawful, but still refused to act on the advice of his ministers, it would not necessarily be unconstitutional, but it would be unwise unless he was confident that other responsible ministers capable of carrying on government could be found. If a court had held an action to be illegal and ministers persisted in doing it, the advice merely noted that the position would require, quote, "further consideration," unquote. On the 6th of May 1932, the Commonwealth Government issued a notice that required state public servants to pay state revenue from particular taxes into a Commonwealth bank account. This notice was issued pursuant to the Financial Agreements Enforcement Act 1932. It expressly provided that state public servants were not to pay such amounts into the state treasury. This conflicted with the New South Wales circular of the 12th of April. On the 10th of May, a further circular was issued by the New South Wales Premier's Department. It required state public servants to deposit all tax revenue received with the New South Wales Treasury, not in any bank account. The Sydney Morning Herald reported on the 10th of May that state tax officials are bewildered by the conflict of federal and state instructions. The Governor immediately contacted Lang and sought a copy of the circular. He then wrote to Lang noting that it appeared to him that the terms of the circular directed public servants to breach the law, and he asked Lang to provide, quote, proof that the instructions in the circular are within the law, or alternatively to withdraw the circular at once, unquote. The fact that it was a Commonwealth law being breached rather than a state law was significant. If a state law, such as the Audit Act, were breached, the breach could be rectified or dealt with by the enactment of retrospective legislation by the state parliament. The breach of a Commonwealth law was a much more serious matter because it was outside the power of the state to rectify. Lang replied to the Governor on the 13th of May that the circular represented a cabinet decision and would not be withdrawn. He offered no advice as to its legality. The Governor replied that he assumed that this meant that Lang did not dispute his view that the circular was in breach of federal law. If you want to see copies of these letters on the crucial day of Lang's dismissal, they are all published in a book by Bethia Foote called Dismissal of a Premier, the Philip Game Papers, which you can often find in second-hand bookstores. After a meeting between Game and Lang that afternoon, the Governor again wrote to Lang, noting that at the interview, Lang neither admitted nor denied that the circular was in breach of the law. He also noted that if ministers felt that they could not maintain essential services without breaking the law, it was their duty to resign. Lang refused to resign, so then the Governor dismissed him. Those of you who've watched my previous video would know that the Mortgages Taxation Bill had passed early that morning, and it would have allowed the Lang government to raise the funds to pay back the Commonwealth, unless, of course, the Commonwealth's rather dubious counter legislation actually worked. It was therefore curious that Lang preferred dismissal over the withdrawal of the circular in circumstances where he now had the legislation that would have allowed him to pay back the money to the Commonwealth. The Governor was also surprised by this response and formed a view that Lang actually wanted to be dismissed from government, perhaps for political reasons. Sir Philip mused on this matter in his correspondence with the King. He wrote, quote, having got his mortgage taxation bill through both houses by the early morning of the 13th, I fully anticipated he would have yielded to my request and would have withdrawn the offending instruction, which should incidentally have left me in a difficult situation. Possibly the action of the federal parliament in rushing through legislation which would have nullified much of the mortgage taxation bill made him realise that the net was closing, and he felt his best tactical move was to force my hand. I do not know. He's a difficult man to understand, and I do not pretend to understand him. I've come to think he is a living Jekyll and Hyde, and there is certainly a large element of good and of great courage in him, which one cannot but admire, unquote. Lang himself showed a degree of relief at his dismissal. The Sydney Morning Herald reported that as Lang was packing up his office, he greeted a reporter with the words, quote, well, I am sacked. I am dismissed from office. Beyond that dramatic admission, Mr. Lang would make no comment for publication. Well, I must be going. I'm no longer Premier, but a free man, said Mr. Lang. I have attempted to do my duty. Mr. Lang then donned his greatcoat and hat, picked up his attaché case, and went out by the main door. The evening of the dismissal, the news raced through Sydney like wildfire. While Lang's supporters were devastated, many people were jubilant. The press reported scenes of celebration that were reminiscent of the armistice. The new Stevens government was appointed and formed a caretaker government until an election could be held. Lang, in his campaign literature, argued that the Mortgages Taxation Bill would have solved all the state's financial problems. In a rather melodramatic flourish, he continued to say the following, quote, we had beaten the newspapers. We had beaten the governments of other states and the Commonwealth. We had beaten the courts. We had won over the Legislative Council. But as we reached out to take for the people the fruits of their victory, the hand of the assassins struck, swift and unerring, and the people's freedom, so hardly gained, has been momentarily taken from them." Unquote. It was reported in the press that if Lang was to be returned at the election with a majority, he would insist upon the immediate recall of Sir Philip Game. Lady Game wrote to her aunt during the election campaign, observing that if Lang were to win, quote, "we are to be fired forthwith, but I shan't begin to pack yet, although I may have the trunks prepared." Unquote. It was not necessary for Lady Game to pack. The election was won by Bertram Stevens and his United Australia Party, which obtained a clear majority. The Commonwealth Government ceased its disputes with the state and provided it with financial assistance again. And the banks and the markets, reassured of financial stability, began lending and investing again. The money in the Treasury strong room was packed up in boxes and sent back to the banks before a very appreciative crowd, including the new Premier. The King's private secretary, Sir Clive Wigram, sent a letter to Sir Philip Game incorporating the views of the King. It went as follows, quote, "His Majesty feels that no one could have acted with greater restraint and patience than you did in the face of strong pressure brought to bear upon you by the press and a large section of the public to take prompt and drastic action against Mr. Lang. You gave your Prime Minister every chance, but when his methods became illegal and unconstitutional, you carried out your duties as the King's representative." Unquote. Thank you once again for watching the Constitutional Clarion. I will conclude this series of videos with one more reflecting on the constitutional issues concerning the exercise of this reserve power by Sir Philip Game. And I look forward to seeing you then. Goodbye.